Crime in Court. My name is Heather, and this is another update in the Delphi case. So as you can see from the thumbnail, we are going to go over some court docs. We're going to talk about delays, admissibility, and a petition to strike findings. So let's begin with so first off, this was a filing from the defense. They had, so earlier this week on the 7th, so Monday of this week, there was a hearing, a pre-trial hearing, because originally trial was supposed to begin May 13th. You know, jury selection had, the jury summons had all gone out, and jury selection was about to begin on May 13th, which is obviously next week, and we're not there. So they had this hearing. During the hearing, they eventually changed the date of the trial, which we'll get to, but they talked about a lot of other things, a lot of other motions and things, and I'm not sure what they talked about specifically, but they did talk about the motions in limine, which included the filing from the prosecution where they basically want to tie the defense's hands and tell them you can't talk about odiness, you can't talk about ritualistic sacrifices and things like that. You can't bring any of that in to trial. Nothing that was talked about in the Franks. And they want to basically handicap the defense from defending their client. And so they had this pretrial meeting or hearing, and this is coming from afterwards. Andrew Baldwin wanted the transcript. So this is a Preacipe for transcript. Basically, it just means like it's a notice. I want this court document. Comes now the accused by counsel and files his Preacipe for transcript in the above captioned matter. So Indiana versus Richard Allen. Regarding said transcript shall be of the hearing held on May 7th, 2024 regarding the pretrial conference and motion in limine in front of the Honorable Judge Francis C. Gull, special judge, held in Allen County Superior Court. So basically this was a notice to Fran. Hey Fran, we would like the transcript of that hearing. She did honor that, and they are going to be getting that. I just saw that order come through today, but we're not going to read through the order. But so they are getting it. Eventually, the transcript will be ordered for the hearing so that they can deal with whatever matters they dealt with in person. So that was the first filing that I wanted to read to you guys. The next filing is from Nick McLeland. This is basically stating, so there's still some pending motions on admissibility regarding some of the evidence, and this is Nick McLeland requesting a ruling on that. So comes now the state of Indiana by prosecuting attorney Nicholas C. McLeland, and hereby requests a pre-trial ruling as to the admissibility of certain communications made by Richard Allen to a psychologist. So something that he said to some psychologist they want, and they want it admitted. In support of this request, the state submits the following. 1. That Richard Allen has access to mental health services at the Indiana Department of Corrections, where he has been housed for safekeeping pursuant to court order. 2. The mental health personnel employed by Centurion Health provided psychologists and or counselors to whom Richard Allen has made statements. Number 3, that in particular, Dr. Monica H. Walla, psychologist, a licensed psychologist to practice in the state of Indiana, has documented statements of Richard Allen which the state believes fall within an exception to confidentiality pursuant to Indiana code, whatever code. Number 4, Indiana code, same code, privileged communications between psychologists and clients states, in part, a psychologist licensed under this article may not disclose any information acquired from persons with whom the psychologist has dealt in a professional capacity, except under the following circumstances. 1. Trials for homicide when the disclosure relates directly to the fact or immediate circumstances of said homicide. 5. The state intends to offer into evidence the testimony of Dr. Monica Walla as documented in her reports entitled Department of Corrections Behavioral Health Self-Deletion Observation. So, does it have something to do with that? His self-deletion? But that's not a confession necessarily. If he wants to self-delete, that doesn't mean that he's committing to the crime. Or admitting to the crime. Number 6, that the state seeks this ruling for the sole purpose of expediting the presentation of evidence during trial to put the defendant on notice as to the evidentiary exception and to obtain a pretrial ruling on admissibility. So something he said the prosecution wants in evidence. Wherefore, the state requests the court provide a ruling to the admissibility of Richard Allen's statements through testimony of Dr. Walla testimony per the exception cited to whatever code that is, and for all other just and proper relief in the circumstances, signed Nicholas C. McLeland. So they want to bring in some statement that he made to a psychologist, which they think might prove he's guilty. I don't know. And so that's what they want. All right, so the next interesting filing that has come forth was this one, a petition to strike gratuitous and demeaning commentary and or findings from contempt order. So that order that we came out with, it was, I read it in another episode here. We read through her findings of contempt, and she's very derogatory and demeaning towards them. So I can understand why they would want some of that language stricken from the record. So comes now counsel for defense counsel, and in support, so this is David Hennessy, in support of this petition alleges and states, 1. On January 29th, 2024, Prosecutor McLeland filed his verified information of contemptuous conduct. Number 2, despite Mr. McLeland's failure to follow proper procedure, the court afforded him a hearing on his spurious allegations. See defendant's counsel's motion for summary denial of state's verified information for contemptuous conduct incorporated herein. 3. The only issue before the court was whether Mr. McLeland could prove beyond a reasonable doubt that defense counsel acted willfully and intentionally in relation to purloined discovery material. What the heck is purloined? That sounds like a dirty word. Purloined. Means to steal. Steal something. Interesting. All right. So in relation, okay, let me reread that sentence. Number 3, the only issue before the court was whether Mr. McLeland could prove beyond a reasonable doubt the defense counsel acted willfully and intentionally in relation to purloined, stolen discovery materials and accidentally misdirected email and violating a gag order, which wasn't even in place. 4, the court held that Mr. McLeland failed to meet his burden. 5, the court referenced the preponderance of the evidence standard was unnecessary and not applicable to the issues raised. So the things that she said, like, they weren't necessary and didn't need to be in her filing. So let's get it off the record because you're disparaging some really good lawyers here. Number 6, several defense counsel with over 100 years of combined experience testified and submitted affidavits that the defense counsel in this case conducted themselves properly, typically for counsel representing a citizen accused of crimes and with due diligence and care. The court has no experience, number 7, in representing a citizen accused of committing a crime. True. that threw me off a little bit. All right, number 8, the court's commentary and findings of sloppiness, negligence, and incompetence are outside the issues, not supported by the evidence, gratuitous and unnecessary, demeaning, and have no legitimate purpose in relation to the court's order. And I love that they put that in there. That's great. I mean, it's true. She came out like attacking them, disparaging them. I would almost say close to defamation, defaming them, And these are well-respected men of law who have been practicing law for years, and it's not right what she is saying and doing to them. Number 9, the Office of Judicial and Attorney Regulation provides support staff to the Indiana Disciplinary Commission, Judicial Qualifications Commission, and the Judicial Nominations Commission. The Disciplinary Commission investigates and prosecutes alleged attorney misconduct. Adrian Meering is the Executive Director of the Disciplinary Commission as well as the Office of Judicial and Attorney Regulation. So, yeah. Number 10, in ruling on most of the defense pleadings, the court simply wrote denied without hearing. The lack of such brevity with the contempt order illustrates the gratuitous nature of the demeaning comments. Number 11, the comments and/or findings referenced herein is another exhibition of the court's bias against disdain for an animus towards defense counsel. It is additional cause for recusal. Recuse yourself, Judge Gull. Wherefore, counsel respectfully prays the court to strike the offending language and reissue the order. And then get the hell off the case. That's what I would say. All right, so this is the order. So that was, that's the motion to strike. All those things, we've gone through. Let's see if I can even find the link. I think I have it saved in my links here, but it's going to take a minute to come up. My computer's being so slow. So we can go over, let's see. I thought I had. Oh, I do. Here's her order on the contempt hearing. So the state proved by preponderance of the evidence that defense counsel was sloppy, negligent, and incompetent in their handling of discovery materials. Counsel failed to properly secure evidence and discover material. No, they were actually betrayed by a confidant, a friend. It's ridiculous that we're even here. So can I make that slightly bigger? What else does she say? So she calls them, sloppy, negligent, incompetent. She says that they were deliberately negligent or whatever. Maybe not deliberate, but counsel was negligent over their material. Despite the court's findings of sloppiness, negligence, and incompetence, the state is required to prove the counsel's conduct was willful and intentional, and they didn't do so. The state has not met that burden. So that's all she needed to say in here. But she didn't need to even say this part, the sloppiness, negligence, blah, blah, blah. She could have just said, the state is required to prove this, and they didn't. So there you go. I thought she said some other things about them, but I can't remember now. I'm not finding it. And here's where she talks about that Adrian Meering, because she thinks, Judge Gull thinks that the press release that Baldwin and Rosie put out to try to defend their client so that he wasn't totally persecuted in the public by the media and everyone else, they put out a statement to defend their client, which they have every right to do. And but she's taking it as, nope, that went against our professional rules of conduct, and I'm going to submit you to this Adrian Meering person for review for your ethical misconduct, which is such BS. So that's what that was about. That portion of this. So the Office of Judicial and Attorney Regulation provides support staff to the Indiana Disciplinary Commission, Judicial Qualifications Commission, and the Judicial Nominations Commission. The Disciplinary Commission investigates and prosecutes alleged attorney misconduct. So if they thought that Andrew Baldwin and Bradley Rosie were not acting on the up and up, that's what they should have done. Not gone through this whole rigmarole, which was just a parade. It was wasting time. That's all it was. All right, so let's move on to the final reading, or the final one that I have for you. This is an actual order from Judge Gull. This is regarding the moving of the date and all that. So this is the official order. Defendant appears in person and with counsel. That was on the 7th that they appeared. So they had their pretrial on the 7th. This is her order issued on, it says the 7th, but it wasn't publicized until the 8th. So the defendant appears in person and with counsel, attorneys Bradley Rosie and Andrew Baldwin and Jennifer Auger. State appears by prosecuting attorney Nicholas McLeland and deputy prosecuting attorneys James Luttrell and Stacy Diener. Hearing held on defendant's motion on pretrial hearing filed April 30th, 2024. Defense counsel report to the court that the scheduled trial dates of May 13th through the 31st are inadequate for trial. Defendant waives his speedy trial and moves for a continuance. And this is because they're forcing their hand to do this, because it was either have the trial now and not be guaranteed enough time to complete your trial, your portion of your case, because the state could take up the whole time, because she didn't schedule enough weeks for this trial. What's that, like 2 weeks? There's no way that this case is going to be done in that time. And that's with jury selection too. So no way. All right, so defendant waives his speedy trial and moves for a continuance. State objects as they are ready. Get out of here, state. You just want to object because you object to anything the defense does. And they are not. I'm sure the state is not ready and is happy for the delay, because they can just keep coming up with more delay tactics because they don't want it to go to trial. All right, so the defendant waives his speedy right trial. State objects as they are ready for trial, but leaves it to the court's discretion. The defense motion granted. So it is granted that the jury trial is going to move now to October 14th through November 15th. So she's giving them more time now, which is really important. And in the grand scheme of things, it's probably best, since Baldwin and Rosie have just been getting hit after hit after hit of discovery thrown at them. Just some amounts of the discovery, big, huge amounts that they have to go through. And they're getting bombarded on purpose, I think, from the prosecution. All right, so the defense motion granted. Jury trial is reset for October 14th through the 15th at 9 a.m. in the Carroll Circuit Court. Defendant's motion to compel and request for sanctions. Defendant's 2 pending motions to suppress. The state's motion in limine and state's motion for ruling on admissibility are all set for hearing May 21st through the 23rd. They're going to go back to court this month and hash out some other things, hopefully, at 9 a.m. in the Carroll Circuit Court. Defendant's 3rd and 4th request for Frank's hearing will be ruled upon and not set for hearing unless necessary. It's like, bitch, come on, just give them a hearing so that they can show you why this stuff is relevant and necessary to come into trial. It's so frustrating. It's like, okay, we're going to have another hearing, but we're not going to talk about the Frank stuff. We'll do that at another time if necessary. I don't think we need to do it right now. It's like they have given you 4 notices that you are not paying attention to, either you're not paying attention, or you yourself, Gull, are deliberately complicit and trying to cover up something going on in your town, in your county. I really do think that she is in on it. I honestly do. Either she's being threatened, or she's part of the order, part of the whatever boys club that ends the lives of little girls in sacrificial manners in the woods at night by the moonlight. I think. I don't know. I'm just speculating. I don't think that their lives were taken at that time, especially because of the geofence data and whatnot. I think they were taken somewhere and then brought there later. That's my opinion. But what do you guys think? Let me know in the comments below. I hope you enjoyed this quick little update. I try to get through these quickly so we can just kind of stay up to date with what's going on in Delphi. If you could, please give this video a like on the way out. I would really appreciate it. And if you're not subscribed, please think about subscribing, because I do updates on Delphi. It seems weekly, sometimes multiple times a week, depending on how many filings are coming out. So I try to keep you guys up to date as much as possible. So please hit that like, subscribe, and I will see you on the way, or I will see you in the next one. Take care, guys. Bye. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.